All right, so why don't we get started? We do have a committee of the whole meeting that's scheduled for 5:30, and I believe Attorney D'Souza has a matter at 5 o'clock that's going to require her to leave at that time. So we'd like to get started quickly. So we've got at least a half hour, if not a little bit more, to commit to this. So the only item on the agenda, we'll call this meeting of the General Government Committee to order. The only item on the agenda is an ordinance entitled Court Enforcement Inspection Ordinance, sponsored by Councilor Hurst. And it's before this committee for some further review. And Councilor Hurst asked that the building department, assessors department, and law department be here to answer any questions that he or members of the committee or council might have. So with that, I will turn it over to you, Councilor Hurst, and can tell us a little bit about your proposal.
Thank you, Councilor Fenton, and I apologize in advance. I'm actually under the weather, so excuse me if I end up coughing or voice sounds a bit raspy. This ordinance is pretty straightforward. This ordinance prohibits code enforcement, the assessors department, and the building department from entering the curtilage of a residential property without either getting consent from the individual who is 18 years or older, who is authorized to permit entry onto the property, or unless these individuals from these departments are accessing areas that are in plain view in which they can see from the outside of the property, or unless it's an emergency situation in which either code enforcement, the building department, or the assessor's office have to get onto the premises to protect or preserve life, or to avoid serious injury to an individual on the property. These departments, as far as I'm concerned, and based off of what I've witnessed firsthand, have really made this sort of part of their practice and procedure to enter an individual's premises without receiving any sort of permission to enter. And I know Attorney D'Souza and I, at one point in time, when I had an issue with this happening on one of my properties, probably 5 or 6 years ago, had mentioned to me that, you know, as long as they had a no trespassing sign on their property, that this particular entry is acceptable. And based off of, you know, my research, it seems to me that we're stretching the Constitution, as I interpret it, a bit. And it also seems to me that the residents who are on these properties ought to have an opportunity to, at the very least, say no without a no trespassing sign being posted. I also was, you know, fairly stunned to learn that the inspectors have badges, and those particular badges allow them, on the actual badge, it says it allows them to enter at reasonable times any building, structure, or premises in the city to perform his or her duties. It also says that any person that obstructs an inspector from carrying out his or her duties could face criminal or civil charges. And so that language in and of itself, in my opinion, certainly it seems like it's in direct conflict with the Fourth Amendment, and if anything, it certainly gives the code enforcement the ability to present this particular badge. Our residents are likely in a position where they're already a bit distraught that they're having these individuals on their property, and the likelihood is high that they're just going to allow these individuals to come in and enter their premises, not knowing that they could say no. And certainly based off of what is on their badge, it doesn't appear that they're able to say no without being subjected to a potential civil or criminal civil or criminal charge. And so The other reason for implementing this is because there have been a number of instances for our code enforcement individuals and our building department individuals in which their safety has been put in jeopardy. I know there have been some cases at the very least in the building department in which inspectors who were on individuals' properties were bitten by dogs when they've gone on the properties without permission. And there also was one time in which the assessors, based off of my understanding and the folks that I've talked to, where the assessor went into a particular property and actually broke his finger. And this individual did not have permission to enter the property. So this particular ordinance not only protects the residents from having their, having individuals come onto their property without their permission, but it also seeks to protect the individuals who are performing their duties and keep those individuals safe as well. And so I wanted to make sure that the building department, as well as the assessor's office and certainly the law department, had an opportunity to weigh in. This particular ordinance was drafted by myself, and then I sent it to Attorney Shea, and I guess he got it stamped by other folks in the law department. And so it seems as though it's been sanctioned by the law department as well. Just a couple quick excerpts, or actually one. A year ago, 1699 Parker Street, I bought this particular property for my mother-in-law, or my grandmother-in-law. And as I was pulling up to the property, I saw an individual from the assessor's office, and I only knew because the individual had, it seemed like he had a city car, and I know what that city car looks like, but he was coming from the back of the premises. And I mean, when you have to walk a long way through the driveway and through sort of like an alley and to get into the actual backyard itself. And so, at that point in time, I just was taken aback at the fact that folks had the audacity just to come on the property without asking anyone's permission. And if you were anywhere else, in this country, who knows what would have happened to this particular individual. And so I felt violated. And I know if I felt violated, this happens much more regularly than meets the eye. And I know code enforcement has ticketed numerous individuals when they've gone onto the property as a matter of practice with even police officers, during some of their Saturday sweeps. And so, and then in other instances as well. So this ordinance really is a start to hopefully rectify this and make sure not only code enforcement, building and assessors know the rights that residents have, but also that the residents know their rights. Since putting forth this ordinance, the assessor's office seems to have attempted to change their practice, as it looks like they are now notifying individuals in advance of their intent to enter the individual's premises and actually go on the premises. We can get to that at another point in time, because I have some significant concerns about what their practice is now, but we can get there after. So with that said, Mr. President, I actually have a few questions of the law department as it relates to this ordinance, but I can certainly turn it back over to you so that you can proceed as you see fit.
No, thank you, Councilor Hurst. I think it'd be best if you asked your questions. I would personally, that's a lot of information, and I think it'd be useful if, in addition to your questions that you have for the law department, if you could just sort of summarize what changes you would like this to bring about in terms of municipal practice, like what things are currently happening that you wish not to continue.
So individuals are going on to people's properties and ticketing individuals without their consent. And so I don't want any code enforcement official, any building department official to go on to residents' properties without their consent for the purpose of ticketing them. If they want to go to somebody else's property who gives them consent, I have no problems with that. And if they want a ticket, what is in plain view, I have no problem with that. And if there's an emergency situation and they want to ticket individuals once they're inside for an emergency, I have no problems with that. From an assessor standpoint, I just don't think any building department should be on anybody's property without their consent unless it's an emergency, which would lead me to my first question. But that really is the general gist. This is happening regularly, and you know it's problematic. And I've heard from a number of residents, and it's happened to me. And I just, you know, it ought to stop.
Okay, that's
So
pretty
this
clear.
really this also just codifies locally what you know, what is very clear in the Constitution in terms of what folks are able to do and not do.
Okay, I think that's fair. So I have questions about that, but why don't you ask your questions first? It's your proposal.
So I guess my first question would be for the law department. And, you know, I originally cited code enforcement in the building department and in the assessor's office. And that's how I wrote the ordinance. But I guess my question to you is there a way in which we can draft this that incorporates all departments in the city of Springfield?
Well, do you want me to answer?
Oh, please, yeah.
Yeah. I don't know. I mean, I would have to look at it on a case-by-case basis. First of all, I want to clarify, I think that the sign off in the law department was a sign off as to form. So I want to make sure that that's clear. And the second thing is, we had made some suggestions separate from approving it as to form with regard to some wording. But I don't, so for example, I would have to look at what police powers are vested with, say, the fire department, like, so they have to do annual inspections, you know, for obvious reasons. I don't know what their police powers are, or and so in this ordinance, you're talking about getting an administrative search warrant. And if it were, so I'm just trying to think out, I'm talking while I'm thinking, which is dangerous, but so I don't know if that would be the correct vehicle. You know, maybe you need to just get an order of the court, because I don't know that there would be, I don't know if it would be a search warrant under those circumstances. It would be, because you're not really there to search, you're just there to certify that, say, the sprinklers are working. So maybe we could look at expanding it to include the words administrative search warrant and or order of a court of competent jurisdiction. Something like that. So I'm trying to reflect back what you're asking me. So you would like it to say, so any routine or mandated inspection, people have a right to say no, and that at that point, the burden would kind of shift back to the city department to either apply for and be granted an administrative search warrant or get an order of a court of competent jurisdiction. Am I accurately?
Yes.
Okay.
Yes.
So that would be my suggestion on that, and I'd need to kind of percolate it through a little bit.
Attorney D'Souza, it is no rush, and I'm amenable to whatever language you think is appropriate. I think, you know, my initial concerns were with the building code enforcement and the assessor's office. So to the extent that, you know, we limit it to those departments, I'm content with that. It seems to me though that it ought to be applicable across the board, and I'll certainly let you think through the language.
Yeah, I mean, obviously, and there's an exception in here anyways for emergencies. So,
emergency situations.
So yeah, you know, obviously we don't want firemen to have to stop and knock. So
Of course.
but that does yeah. So those that would be my initial response.
If I may I?
Yeah, sure, please.
Attorney.
I think, Justin, to your point of all departments, the main ones that access the most, I think, have been outlined both in the ordinance, the way you drew it and the way we did. Any other department going there, I would imagine if they would, the only one I could think of that would be the health department, and they're generally called to go because there's a health issue. Streets, public works, if they went on the property because they're going to do something, they've got to get permission anyway. So I would think in those cases, rather than casting a big net and causing confusion in the drafting, I would think if any department went, it's going to be city policy that if the owner of the property objects, you simply go get a warrant. And I think that would self-cure unless we can, come up with a list of others. No one's going to complain when the fire department shows up, I don't think. So, I think the main ones that are affected are clearly listed in this ordinance. I do want to point out that in the draft that I sent over to you, I changed the wording because in reading yours, and we can talk about this, it says, and I'm just going to pick it up, somewhere after building department must obtain an administrative warrant to enter the curtilage of a residential property in order to perform an inspection for assessment or valuation. And I read that to be that before you could even go on the property, you'd have to get permission. And you can't get a civil warrant. The court is not going to issue a civil warrant until you've got a denial by the property owner. So we'd almost have to go to court on every single property if we followed that way I interpreted that language. And we wouldn't succeed unless we could demonstrate that first off, we'd been denied. So I took that piece out to simply say that if the property owner denied access, then a civil warrant would be obtained. I also took out the language of curtilage because curtilage is not, there is no case that defines curtilage specifically. There's no legal definition of curtilage. It's a word of art that is a case-by-case basis, and it varies from case to case. And to put that into the language, we're putting a burden both on the inspector trying to get inspections, and we're opening up to having legislation, I think, that would create more cases than it would solve, because the law on curtilage, and I just want to sort of, if I may, point out a few things that I came across, if I can find my notes. And I'll talk about one case, if I may. And that is the Air Pollution Board versus Western Affiliate, if I read it right. And that basically adopted what was called an open fields doctrine. And it said the court determined that the inspector in this particular case, the court left intact the ability of a city inspector to inspect without warrants if such inspection occurs pursuant to a valid regulatory scheme. So that's mainly going to affect the outside of the property, because you're not getting into a property without a warrant if the owner objects, okay? But the court determined that the inspection was, in this case, a reasonable search, even where the owner subsequently objected to the inspection and when the inspector had actually entered onto the property. We're talking about the curtilage here, okay? And so there's another case which greatly defines curtilage. There's a lot of language, and that is Elder versus Bogart. An inspector entered onto a private commercial premises in order to conduct a visual inspection of an exterior building. And the court, relying on the Air Pollution Board, found that the inspection was permissible under the open fields doctrine because the inspector was viewing a portion of the premises that could have been viewed by any person in the vicinity of the property, and because he was on a portion of the property from which public was not excluded. So I took out the word curtilage because, as I said, there's no clear definition of it. Every case is going to be different, okay? And in one of the leading cases, the Dunn case, I'll go on just to fill this in, it states that curtilage questions should be resolved with particular reference to the 4 factors to be extended that they bear upon whether the area claimed to be curtilage is so immediately tied to the home itself that it should be placed under the home's umbrella of protection. And they list 4 items to look for. Number 1, the proximity of the area to the home. 2, whether the area is within an enclosed or surrounding home. 3, the nature and use to which the area is put. And 4, the steps taken by the resident to protect that area from observation. So the case even points out if there was no fence, you're clearly able to go onto that property. And the cases point out that you're not trespassing if you're on the outside carrying out a legitimate government operation. So, we can begin to now get in the weeds. If they put up a fence, but there's no gate, depending on the type of fence, there's some cases that deal with the type of fence. So I thought it best to take that language out, because it's just opening up Pandora's box, and every case is going to be different. So I just wanted to point that out, that in the language approved by the city law department, we took that word out and we clarified clearly that there has to first be an objection before we go and get the warrant. And then we sort of added on later, because I think in reading it that the warrant would be justified to go on the property if you'd be able to go to the front door and ring the doorbell without a warrant, is basically what it does. Okay, so that's some of my 2 cents worth here at this point.
Much appreciated. I'm quite content with that. And I actually am looking at the draft that I sent you. So I'm trying to pull up the other draft, thinking that it hadn't changed, but based off of your explanation,
I changed your draft.
I got it. Based off of your explanation, that makes perfect sense to me.
Thank you, Attorney Shea. Also welcome Counselor Govan. Are there any final questions for Attorney D'Souza? She does have an appointment at 5 o'clock and needs to leave. I think we'll have at least some more time for the meeting, but anything for Lisa?
The only other question that I had, and maybe it's for Lisa / Attorney Shea, and I apologize, Counselor Fenton, I should have raised my hand, is we limit this to residential. And I'm looking at my draft, so if we did change it, let me know, Attorney Shea. But does it make sense to include commercial as well? I mean,
they're all under the case law. Attorney Hurt,
yeah.
Under the case law, commercial property and residential are all thrown in. You can't, if an owner of commercial property were to object, you got to get a warrant. Just because it's commercial property doesn't mean that the rights are waived. Okay.
Mad it out.
Yeah.
And that explicitly says that in the ordinance that you changed, Attorney Shea.
I'd have to read it and see if I put that in, but I mean.
No, you did. You put in, if entry has been denied by the landowner or business owner.
I got it. Okay, good. Okay. That's all I have, Counselor Fenton. Those were the only 2 questions I had. I'd love to hear from Steve or I don't know if Patrick's here, whoever else is on the call, and just what their general thoughts are. If whether this works, whether this makes sense.
Thank you very much. I have a couple of questions too. If Steve or Patrick, you have something you want to say right now, I won't stop you, but I do have some things I'd like to ask.
I definitely have.
Counselor Fenton, I have questions as well, but I can't use the hand thing while I'm driving. So when you're finished, if you give me a couple of minutes to ask questions too.
Happy to, yes.
Thank you.
So Patrick, you were starting to say something?
Yeah, I definitely have comments to Counselor Hurst and the ordinance. I don't know which order you'd like to go in though. If you'd like to ask questions.
Well, I mean, you're
first,
talking
or...
now, so you're talking now. So let's.
All right. So yeah, essentially, the biggest issue for us would be, as you mentioned, the curtilage, Attorney Shea and Counselor Hurst. You're right. We do walk around the property. If the process right now is we'll go to someone's home, knock on the door. If we are allowed entry into the house, if someone's over 18, we will walk through the house and make sure that the property record card is accurate. If someone is not home, we will walk the exterior of the house to make sure that we get a full list and measure of the house. That is a requirement of the law from the Department of Revenue. So Massachusetts general law does require assessors to assess every property at full and fair cash value. They have granted the Commissioner of Revenue authority to come up with guidelines to make sure that all properties are assessed at full and fair cash value. One of those requirements is in it's called a certification standard. And in those standards, it requires us to relist and measure every property once every 10 years. So I just kind of pulled some numbers. In calendar 22, we did walk around 2,848 houses where someone has not been home, and we were still able to at least list and measure the home. So I don't know what the administrative cost would be to get a warrant for every single one of those if someone's not home, but it certainly would be burdensome, costly, and we may not even be in compliance with the Department of Revenue certification standards. On that note, the Massachusetts Association of Assessing Officers have introduced House legislation that has gone through 2 readings of the House right now. And that is to supplement, to alter the section that requires full and fair cash value to allow assessors to at least walk around the property. So that has gone through 2 readings of the House. It still needs to go through the 3rd of the House. And then that will be picked up after the election. And then, of course, the Senate would have to vote on that as well.
Okay, thank you, Patrick.
Sure.
Councilor Hurst, I see you have your hand raised. It probably is in response to Patrick's comment. So why don't you go ahead?
Just can't believe that that's it. I just can't believe that that's accepted, right? Like, we can't just go onto people's premises. I can't believe that the law would be in direct conflict with the Constitution. I'd be curious to see what the state legislature does. But I can't imagine that they're going to allow folks to allow you all to just go on people's properties. And the fact that you've done it in such large numbers makes this ordinance even more relevant and imperative that we implement. I mean, that just is inexcusable. I mean, and I'm more so concerned about you all as well. I mean, but it seems problematic to me. So I'll turn it back over to you, Mr. Chair. That's a lot.
Thank you, Councilor Hurst. All right, so I have a couple questions, and then Councilor Whitfield, we'll get to you. We've got about 15 more minutes, and then we've got to go for our committee of the whole. So one of my questions is it relates to sort of the badge item that Councilor Hurst was referring to earlier. And when I was reviewing this for its original submission, one of the things that I noticed, Steve, is that the Mass Building Code under CMR 115.6, it states, and this is a quote, "In the discharge of his or her duties, the building official shall have the authority to enter at any reasonable hour any building, structure, or premises in the municipality to enforce the provisions of the building code." And then it goes on to say that if I'm not going to read that verbatim, it's a little bit longer, but basically it says if the owner or the occupant refuses or inhibits in any way, then you can go get an administrative warrant. But it starts with shall have the authority to enter at reasonable hour any building, structure, or premises. And so I imagine that if there is language to the effect that, I haven't seen the badges, but if there is language to the effect that Councilor Hurst was speaking to earlier, it's probably a verbatim quote from that regulation, which gives the building officials under state law, which preempts municipal action, the authority to conduct these reasonable hour searches under the building code. And so can you speak to that at all, Steve? Is that accurate, what I just said?
Yeah, you are accurate. That is the language right out of our administrative codes, Article Chapter 1, that states what our rights are. That's why it is on their badges, because it states exactly what the Mass General Law allows us. And you are correct. The inspectors are trained right from day one. If somebody says no, it's no. And then we have a process for that. So you guys have probably heard me say this many times at the council meetings where I've had councilors say, well, we're going to get you more inspectors. We're going to get you more inspectors, Steve. And I've said it many times, I don't really need any more inspectors, but I need attorneys. Because if I can't prosecute, it doesn't matter how many inspectors I have out there, because this is the process where if people say no, and we need to get administrative search warrants, this is where a large part of Amber's job and Lisa's job came in the past for supporting our court cases. I mean, we run hundreds and hundreds of court cases a year, and our inspections from them points are based on the court's decision to allow and instruct us on inspections from the interior dwellings.
And Counselor Hurst, your point in relation to what Attorney Shea was saying earlier about Fourth Amendment, unreasonable search and seizures, but also recognizing that there is this curtilage issue. I mean, is it your intent that municipal agents wouldn't have the authority to even walk down an open sidewalk to knock on the front door in order to be?
Absolutely not. No, they absolutely, I mean, because that's the only way in which they can get consent, right? Is to go in and knock on a door. My issues are more so when they're going to the backyards and they're walking on premises, which I've heard of a number of times and which has happened to myself, to cite folks, right? And then the way in which they're getting inside the properties, if they're only showing the badge, then nobody has an expectation that they can say no. And that to me is extremely problematic. They're not saying the other portion of the fact that the residents have the ability to say no. And, you know, I mean, I just think
like almost advocating for like a Miranda-esque statement to be made.
Exactly. You have to, because otherwise people are just taking advantage of it. I'm not saying that happens all the time. I mean, I'm sure there are times in which there's good reason for folks to get inside a property, but people have to know that they can say no. And in which case, you know, we have the right to do as a city what it is we need to do, get access, if it's necessary.
And just back to the curtilage piece for a minute, because I understand what you're saying about, you know, they can knock on the door, but not go in the backyard. So for you, there's something about the backyard that is sacred, that's different than the front yard. But you could imagine circumstances, and there's plenty of them, where people's front yard is fenced or otherwise impaired. You've got to open a gate in order to access, for example, the front step in order to be able to knock, or you've got code violations that are in the side yard. I mean, I had many examples of neighbors who become upset over code violations that are visible to no one but them, for example. So, you know, your backyard backs up to your neighbor's yard, which is fenced in on the sides, and you can see, you know, all day that there's illegal dumping going on back there, or there's, you know, abandoned cars or things of that nature. But an inspector who's only able to access from your proposal, the right of way, isn't able to cite a person for that. And so it creates this question around, well, what is an unreasonable search and seizure under this? If a neighbor peeks over the fence and takes pictures of their neighbor's backyard, can the building department rely on that to issue a citation? Or is that sacred space that can't be infringed upon without an administrative warrant? I just think we need to think through those aspects of it.
I actually think it's pretty clear. If the neighbor lets you on the property, they can take they can cite what is in plain view, right? They can cite whatever they can see from the sidewalk or from the porch as they're knocking on the individual's door, right? Like, I mean, you have to get access for folks, at least to knock on the door. I mean, I certainly understand that, to get consent. But I think what is happening is that folks are walking all the way down the driveway to see what is in the back of the property without getting consent. What Patrick mentioned was that they go all the way around to the back of the house to value portions of the house, the garage, the shed. and it has to stop somewhere, right? Like, but if someone else gives you consent and you're able to get access based off of that and off of their property, then you can cite whatever is in plain view.
So, but, and not to belabor the point too much, but it is not that clear to me. I mean, if somebody has a fence in their backyard and you reach over their fence and you take a picture of what's going on in their backyard, the example that I can give you, examples that have happened with me and constituents in the last 2 months, that is not clear to me, that is not an illegal search and seizure under this proposal. That it's not in the plain view of the resident, and the resident doesn't have the authority to let the person do it. And even more broadly, you've got, you've got the issue of other data that is not available from either source. And I don't know what the constitutionality of this is either, Attorney Shea, but I mean, I have had residents take Google images of people's yards, their backyards, which are fenced, or the municipal GIS system, and say, look, this guy's got 3 boats back there. And that's the basis for the, that is the purported basis for the citation. And it's not clear to me. I agree with you, Councilor Hurst, that there should be a point, as you say, where it stops. What's not clear to me is where that line would be based on this proposal. I think it needs to be a clear line of this is where it stops. And that's not clear to me right now based on this.
The case law I sent you, Attorney Shea. I'm sorry, Mr. President.
Here's to Michael's point. First off, I think that the example he picked of a neighbor or some other party reaching over and taking a picture, that may present constitutional issue. The cases that we're talking about are not that some random person is going to reach over and take a picture, but that a administrative official from the city acting under a statute which gives authority to do that. And so I just want to revisit that the leading case that we're working off of, all of us here, is the Cameron case, which establishes that the Fourth Amendment right requires that you get the warrant if there's an objection, okay? But it's got to be noted that the Cameron explicitly did not overturn administrative inspection schemes requiring routine periodic inspections of property in a municipality pursuant to a regulatory scheme where we're dealing with the curtilage of the outside of the property. And it's backed up in the Air Pollution Board case where the court left intact the ability of a city inspector to inspect without warrants if such inspection occurred pursuant to a valid regulatory scheme. The court determined that the inspection, and this is the case where someone went on property without permission now, okay, the outside of the property. The court determined that the inspection was reasonable search, even when the owner subsequently objected to the inspection and when the inspector had actually entered onto the premises. So we're dealing with, in the statements I'm making now, I'm dealing with the outside of the property, the curtilage. I'm not dealing with the fact that you can just go into the house without permission. So the court has drawn a line with this open fields document that is different from when we're talking about going into the property. And we've got to keep those distinctions in place between the cases.
Thank you, Attorney Shea. We only have a few more minutes, but Councilor Whitfield has been waiting very patiently. So Councilor Whitfield.
Thank you, Mr. Chair. I want to say that I somewhat agree with you because first I wanted to find out what constitutes an emergency. And so I have a situation similar to one that you mentioned where it's the neighbor's backyard. You can't see the backyard from the side of the house or the street, but you can clearly see it from the neighbor's premises. And like through the window, she can see what's going on in her neighbor's backyard, and it's causing a lot of air pollution. And code enforcement has been there and they ticketed them. But all they did was get some tarps and put over the pollution, whatever's causing the pollution, put over the cars, so to her, that's an emergency because she's been calling code she's been calling me. I mean, I have gotten so many pictures from the same individual. To her, that is an emergency, because when she had backyard functions, they have to smell that and even see it. And so for me, it's not really clear as to, I mean, is it legal to go to her house and take pictures of what they see and then ticket them that way? So I'm unclear on what constitutes an emergency. But also, I wanted to know how much time does it take to obtain an administrative warrant, and what is the cost? Because how much more cost are we going to incur? How much more cost is it going to be to get these administrative warrants? Like, what is the cost of one? Does anybody know?
Attorney Gould, can you answer that?
Yes, thank you, Mr. Fenton. So in my experience, the housing court does not charge us anything to get an administrative search warrant. And the length of time, to answer Councilor Whitfield's question regarding the length of time, it varies. So I've done it a few times. Normally, just so everybody knows, I would file a motion for access normally, unless I needed to do an administrative search warrant. I know now's not the time to explain that. It has taken 24, I would say, 1 to 3 days for an administrative search warrant. In my experience, it's usually pretty quick in my experience. Councilor Whitfield, I hope that's helpful. I haven't had much experience again. I usually do motions. So I hope that's helpful.
So that is helpful, that it doesn't take a lot of time, but also maybe because we don't have a lot of backlog at the moment, that we're asking for so many of them. So that might also be a factor. But what constitutes an emergency? Like,
I think
that's so
it was a massive-
subjective.
I'm sorry, Councilor Whitfield, were you done? You can continue.
Oh, no, I was just saying what constitutes an emergency, because that could be subjective. What's an emergency to me may not be an emergency to someone else, or to code enforcement or any other department. So what constitutes an emergency?
Well, I think that every situation would have a different answer to that. Every department would probably have a different answer to that. And maybe one of the things that can come from this is we more clearly define what that means under this proposal. It sounds like there's quite a bit of implications to this proposal, and you know, the spirit of it, I think, is a good one. Let's create a clear line for what's permitted and what's not. And I think we'll probably need at least another committee meeting to discuss that. And okay, so before we adjourn the meeting, Councilor Hurst has raised his hand.
No, I was just gonna agree with you.
I just had one more yet, because I'm sorry, a lot of information was given. I don't clearly understand these cases. So on the next one, I would love Attorney Shea to just break down the case like to a 6-year-old, and then let us ask specific questions as we go along, because the legal terminology and everything is really like confusing to me. So I just need a little bit more time to read it for myself. I don't know if you could send us the particular case to read, but I don't understand all the language. So
I can send you the cases, and I'll do that, but it might be better if after that's done, I pull out synopsis for you to digest the sections of it, but I can do that.
Yes, please, synopsis, whatever you can do, because I am not a lawyer, and I need like a little bit more time to digest all this information I was given.
I mean, the only thing, Tracy, I can tell you on an emergency is that I don't think any of us always know what it is, but we'll know when we see it. It's kind of a common sense thing. So that may be the guidance that we have. I don't know.
Thank you.
I understand, but I think that's subjective, because to the neighbor, it's an emergency. Like, they've been calling for years, and these cars are still there, and they just cover it with tarp. So that's an emergency if you have to put up with those odors, and I mean, the eyesore is right in the back of your yard. That's an emergency, but to cold to us, is it an emergency? I don't know.
Thank you. Councilor Hurst.
So I was just gonna say, let me, one, thank you for having the meeting, Mr. Chair. And you know, what I'll do in light of the questions is I'll reach out to Attorney Shea. We'll think through this a little bit more and see if we can kind of dot our I's and cross our T's and be a bit more clear and address some of the concerns that folks had. So I will talk to you, Councilor Fenton, and let you know when we might be able to schedule the next meeting after Attorney Shea and I have talked through this a bit more.
That sounds
Does that make
great.
sense?
That's terrific. Thank you, everybody, for your time. I will
Thank
see
you.
some of you in 13 minutes.